Hi, welcome back. Today we're talking about something that affects a lot of self-employed business owners who've been doing things right. Building a business, opening a solo 401k, putting serious money away for retirement. And then you hit a milestone that changes the entire equation. We're talking about hiring your first employee. Most people think of a first hire as a growth moment, and it is, but it's also a retirement planning moment. And it's one that a surprisingly large number of business owners aren't prepared for. So, in today's video, we're going to break down exactly what a solo K is, who it's designed for, and specifically what happens the moment you bring on a qualifying employee, and what your options are going forward. So let's get into it. First of all, what is a solo 401k? Let's make sure we're all on the same page about what a solo K actually is, because there's some confusion out there. A solo K, or a solo 401k, which is often shortened to solo K, and sometimes called an individual 401k or a one participant 401k. Anyway, it's got a lot of names, but basically it's a qualified retirement plan specifically designed for self-employed individuals and business owners who are the only full-time workers in their operation. In some cases, a spouse who works in the business can also participate. Now, here's why it's such a powerful structure for solo operators. Unlike a traditional IRA, which has a 2026 contribution limit of $7,500 for those under 50 or $8,600 for those 50 and over, a solo K allows contributions in two capacities: as the employee and the employer, because if you're self-employed, you wear both those hats. As the employee, you can defer up to $24,500 in 2026 if you're under 50. Now, if you're 50 or older, up to $32,500. And if you fall into the 60 to 63 age bracket, up to $35,750. On top of that, as the employer, you can contribute up to 25% of your compensation, capped at $47,500 for 2026. That's an incredibly large capacity to build retirement savings year over year. And unlike a SEP IRA, which only allows employer contributions, the solo K lets you make employee deferrals also, which often means more money into the plan, even at lower income levels. Now, add this to the fact that a solo 401k can be structured as a self-directed plan, giving you access to alternative assets like real estate, promissory notes, private placements, private stock, precious metals, cryptocurrency, on and on and on. And you can see why this plan is so popular among the self-employed. But here's the catch, and it's a big one, and that's the eligibility rule. A solo 401k is available only to businesses where the owner is the only full-time employee, period, full stop. The IRS structure of a solo K is fundamentally incompatible with having non-owner full-time employees. The moment your business has a qualifying employee outside of yourself and your spouse, the solo K plan must change. Now, what counts as a qualifying employee? For most solo K plan documents, the standard is the 1,000-hour rule. An employee who works 1,000 or more hours in a plan year is generally considered full-time for eligibility purposes. Employees who remain under 1,000 hours, true part-time or seasonal workers are typically excluded. Now, this matters for a few reasons. If you have seasonal staff who pick up shifts but never hit 1,000 hours, your plan may remain compliant, but you've got to track those hours every year, documented and defensible. If someone is hired full-time or a part-timer's hours creep up over the years, that's when you need to act. And acting means not ignoring it, because ignoring it is the worst possible outcome. Operating a solo K after a qualifying employee joins your team without amending or transitioning the plan can lead to plan disqualification. Now, plan disqualification means the plan loses its tax advantage status. That means contributions and earnings that were supposed to grow tax deferred or tax free suddenly aren't protected. We're talking real, potentially significant tax consequences. The message here, knowing the rule is the first step. The second step is acting on it before it becomes urgent. So let's talk about what you can actually do, because you have options, and options mean control. So option 1, convert to a standard 401k. The most natural transition for many solo K holders is opening a standard 401k that covers eligible employees. This new version of your retirement plan can now hold the funds you had in your solo K. You don't start from scratch, but the plan expands, and with that expansion comes new responsibilities. A standard 401k covering employees requires non-discrimination testing. These tests, including the actual deferral percentage test and the actual contribution percentage test, ensure that contributions don't disproportionately favor highly compensated employees. Many small business owners address this by adopting a safe harbor 401k design, which satisfies testing requirements through a defined employer contribution formula. You'll also likely need to begin filing Form 5500 annually if your plan assets exceed $250,000. The upside, you retain the 401k structure, and if the plan allows self-directed options, you may be able to preserve your existing alternative assets holding in a record-keeping account with your self-directed IRA administrator. Remember, standard 401k plans must generally be established by December 31st of the year for which employee deferrals are made. So it has to be done by December 31st. If you hire an employee this year, that plan needs to be in place by December 31st and no later, and don't wait till the last minute. Okay, let's see. Option 2, a SEP IRA. A SEP IRA is a simplified employee pension IRA. It's a simpler structure that works well for many small business owners with employees. Here's what makes it easy. Only the employer contributes. Employees don't make salary deferrals into a SEP IRA. The employer funds it exclusively. This eliminates the salary deferral component, and the administrative burden is generally lower. For 2026, employer contributions can reach up to 25% of compensation with a maximum of $72,000. That's a pretty generous ceiling. SEP IRAs can be self-directed, so access to alternative assets remains an option. And the contents of your self-directed solo K can be rolled over into the new SEP plan. Okay, option 3, A simple IRA. A simple IRA, or a savings incentive match plan for employees, is specifically designed for small businesses with 100 or fewer employees. Unlike the SEP IRA, both employees and employers can contribute. Employee deferrals for 2026 are $17,000 for those under 50, $21,000 for those 50 and over, and $22,250 for those in the 60 to 63 age bracket. That's that enhanced catch-up contribution. As the employer, you're required to make either a 3% matching contribution on behalf of employees who contribute, or a 2% non-elective contribution for all eligible employees. And that's whether they contribute or not. One critical rule: a simple IRA must generally be established by October 1st of the plan year. That's October 1st, not December, October 1st. Option 4, terminate and roll to a self-directed IRA. In some cases, particularly if the business is evolving significantly, terminating the solo K and rolling assets into a self-directed IRA may be the right move. This option preserves full access to alternative assets. A self-directed IRA can hold real estate, promissory notes. I gave you the list before. It just goes on and on. It's all those things you can't do with a brokerage account. Rolling assets from a solo K to a self-directed IRA is a tax-free event when done correctly through a direct rollover. Existing self-directed alternative asset holdings are eligible for an in-kind transfer. You don't have to liquidate to move it. Remember, consult a qualified financial, legal, or tax professional before making any plan decisions. They can help you figure out what is best for your exact situation. Okay, timing and deadlines. Let's talk about timing, because the deadlines here matter and they are not flexible. A simple IRA, just talked about it, must generally be established by October 1st of the applicable plan year. A standard 401k must generally be established by December 31st for employee deferrals to apply for that year. Employee deferrals for 2026 must be elected by December 31st, 2026. A SEP IRA. Employer contributions for the 2026 tax year are generally due by the employer's tax filing deadline, including extensions. The basic message is, don't let a business growth milestone become a retirement plan emergency. Act early, know your deadlines. All right, let's bring it back to the big picture and wrap it up. You built your business, you opened a solo K, you've been putting away serious money, building real positions in alternative assets. That's a story of discipline and smart decision making. The new hire that grows your business shouldn't undo any of that, but it can if you don't plan for it. Know the eligibility rules, understand the 1,000 hour threshold, track employee hours, and well before your first qualifying hire arrives, start the conversation with a qualified plan administrator and a qualified financial, legal, or tax professional about what your transition should look like. Your options are real. Your control is real, but only if you act before the deadline, not after. If you have questions about self-directed IRAs, solo Ks, or other self-directed retirement accounts, visit us at mountainwestira.com. Give us a call at 866-377-3311, or, of course, use the QR code in the corner to schedule a time to talk that works best for you. If you found this video helpful, please like, subscribe, and share. Be sure to leave your questions or future topic ideas in the comments. We answer all of them. And because your question may inspire one of our next educational videos. That's exactly where this one came from. Thanks for watching, and we'll see you next time. Bye.